But I'm asking, Your Honor, that all I'm saying is, even when you consider the homicide investigation, that a $2 million cash or surety bond is excessive. That's my argument, Your Honor. And whether...
Well, you just said two things.
This isn't just a bond hearing. This is a high-stakes balancing act between freedom and public safety. A man not yet charged with homicide facing a $2 million cash bond. Defense says it's excessive. Prosecution says it's necessary. And as this judge starts peeling back the facts, you'll see just how thin the line is between presumption of innocence and real-world risk.
Well, you just said two things to me, because I'm trying to figure out, and I want to make sure I'm getting your point. I understand you're saying that it's excessive. You're also making the argument, I think, that even if the net dollar amount's the same, that when all's said and done, somebody, whoever would put that up, would like to get some of it back.
Well, the bail bondsman doesn't get it back.
Oh, I know. I am aware of that.
But also, the difference is that he could possibly raise $200,000 with the understanding that he's going to show up. These people trust him. They would loan him the money. But with a bail bondsman, he'll never see it again, and nor will the friends and family that are willing to chip in to post a bond. He does not have $200,000. So I just don't think, Your Honor, what I'm requesting is unreasonable to make it a 10% bond. I mean, it's obvious this court is not going to, I've been doing this long enough, not going to follow my recommendation of $100,000 10%, although I don't think it's unreasonable, but at least make the bond as it stands a 10% bond, or make it $1 million 10% bond, or somewhere in between. That's my argument, Your Honor.
Judge, can I just put one thing on record? That discovery is available. They just need to request it from our office. It's been available since I had written a warrant. So I didn't want to make it seem like we were withholding discovery. They couldn't look at it prior to this honor. I mean, I don't think you're making that. I'm just wanting to have the record so that it is available, so they can just request it from our office.
He said he did request the investigator's report, but he hasn't gotten it.
I did email you for the investigator's
PA discovery?
I emailed your personal email.
No, you have to do
No.
Okay. Anyway, Your Honor, that's the argument. I just think that at a minimum, the court should make this a 10% bond. At a minimum. I mean, I've been doing this for 44 years, shown this kind of support at a bond hearing, ever. I mean, he's got strong ties with the community, served his country honorably, put his life on the line in Iraq.
Counsel, I'm not disputing any of that.
I know you.
That's what it is. I also realize I have people who may have led great lives, that when one's looking at it, they've led great lives, that all of a sudden something happens. Don't know what, maybe nothing happens, but all of a sudden something's in front of me that something has happened. And at that point, I have to sort of weigh and balance and try to determine what would be appropriate to have this person released.
Understood.
If I have someone who on one hand met somebody that night and then somehow or another through nothing that really connects them ends up deceased someplace in the field or wherever.
This is where a lot of people misunderstand bond hearings. Bond is not a reward, and it's not a punishment. It's risk management. Listen closely to the judge's example here. Two cases can look similar on the surface, but the risk calculus is completely different. Someone who accidentally becomes connected to a death is not the same as someone whose phone data, movements, and behavior line up with where a body is found. The judge is weighing flight risk, danger to the community, and the integrity of an ongoing investigation. And notice what really matters: phones, tracking data, deception during the investigation. That's why character letters and military service matter, but they don't erase risk. Let me ask you, Should bond focus more on a person's past or the unanswered questions surrounding the crime?
That's one thing. If I have if I have someone who, and I'm not saying this is his case, lured somebody into a house and then all of a sudden kills them and then it takes them out and then dumps them into a field, those things on the surface can look the same. But it's a very different risk analysis in terms of what bond I set to then let somebody into the community.
I understand. Again, I'm not asking for some.
No, I know, counsel, and
But I think his 57 years should count for something, just as a homicide investigation should.
It does. His service to this country, it counts. The support, everything counts. It's a balancing for me. I appreciate the support that's come. I appreciate all the letters, everything that I've seen. All of those are things for this court to weigh. But there's something going on the other side of the scale, too. I can't just take that and say, okay, well, this is it. There's something on the other side of the scale, which the people have pointed out. And the problem, counsel, and this is where I want fairness, is that those things that the people are putting forth, I don't have a count. I'm not hearing a counter from you.
The counter is, Your Honor.
Well, hold it, counsel. I'm not saying, no, what I'm saying is this. I'm not looking for you to give me your whole case.
No,
I'm not looking for you to do all of that. All I'm saying is what the people have laid out, quite frankly, is some pretty damning things if those allegations are there. And I'm not hearing an answer. I'm not saying that I won't have an answer, but I'm not hearing an answer. And I think the reason I'm not hearing an answer or even some suggestion of an answer is because the discovery hasn't been seen.
My answer wasn't going to be on the merits of the facts of the case. My answer was going to be the court said, yes, his life does count for something. And
absolutely.
So if that counts for something, and the homicide investigation also counts for something, which clearly this court believes, and I'm not going to challenge that at this stage. So they both count for something. So they both count for something. There's somewhere in between a $2 million cash or surety bond and a personal bond.
Well,
that's
funny, counsel, because what I would really be arguing in between is what their original request was, which was a $10 million and a personal. So I'm not here to just pick a number. That's not what it is for me.
I understand that.
It's not, setting bond is not a science, it's an art.
Right.
So it's tough to do.
Right. I'm not trying to beat a dead horse, Your Honor. All I'm asking is that the $2 million bond, he simply cannot make. So if the court made it 10%, there'd be if he can raise that, then he'd have to raise $200,000, which is certainly, as I said, not chump change. It's a significant bond. And I think given that he has not been charged with a homicide, but considering that that's something that is in your calculus, that's a fair and reasonable bond. That's my argument, Judge. And given his long life history that anyone would be proud of up until these charges, that is worth something. And what it's worth, in my estimation, is a reduction of the current bond.
Counsel, let me ask you. Okay. I have
This is the moment the defense hits a brick wall. The judge doesn't argue. He asks one devastating question. What do I do with that? Phone data tying the victim to the defendant's house and the defendant's phone tracking to where her body was found. Even without a homicide charge, those facts carry enormous weight. And here's the key problem for the defense. They can't meaningfully respond yet because discovery hasn't been reviewed. The judge isn't accusing, but he's also not blind. This is why bond hearings are so dangerous for defendants in active investigations. You don't have to be charged yet for the court to see serious risk. At this point, the courtroom tension isn't emotional, it's analytical. And the defense knows they're arguing uphill.
I have her phone tracked to his house.
Correct.
I have his phone track to the location of her body, what would you have me do with that? I'm not saying any of that can necessarily be proved, but what would you have when you're talking about me doing the calculus? What do I do with that?
You consider that down the road, perhaps there could be homicide charges of some sort, whether it be murder or manslaughter, and that be taken into consideration and is a factor. But there are also other factors that I think can assure conditions or combination of conditions, meaning tether, passport, third-party custodian, that will assure the safety of the community. So again, I didn't ask for a personal bond in this case. I didn't even ask for a $50,000 10% bond. I asked for what I thought was a significant bond, but obviously the court certainly does not agree with that. And so what I...
Oh, and counsel, I'm wondering, and I know you're advocating for your client, I'm wondering whether or not you would agree with that if you saw at least the preliminary discovery.
What, a $2 million bond?
Well,
I would...
with something other than what you placed in your motion. And I don't know, counsel, and I'm not trying to put you on the spot in that. I'm just saying,
if and when he's charged with a homicide, he could be remanded.
But counsel, let's say it's not even the homicide charge. But I have those factors all in the charges what I have now.
Correct.
That's a huge risk.
Anytime someone is released on bond, there is a risk, Judge.
Yes, but counsel, there are different cases.
That's right.
And if I have some woman who has disappeared, who ends up dead, who the phones are at the same places, and then within the course of that investigation, I have someone that you want me to let out to say, trust him that he will do this, and I look at his life, I also have that other part that he's been deceptive throughout the investigation. All of that's got to play in.
Judge, I don't know, maybe I'm not making myself clear, but what I keep saying the same thing. Yes, if you want to take that into consideration, I understand that. My argument, Your Honor, is that if there's going to be a $2 million bond, it ought to at least be a 10% bond. And that, I think, is a reasonable bond. I've seen homicide cases, murder cases that I've done in my 44 years, and I've done nothing but criminal defense my entire career, where I've seen in homicide cases bonds far less than a $2 million 10%, where there's significant evidence. So what I'm saying, Your Honor, is what's reasonable. And what I'm arguing is a bond that one can't make is not reasonable, particularly where he hasn't actually been faced with, it's not charged with a homicide. So again, I don't want to lose credibility with the court. So I get the message clear, it's come through clear that the bond I've requested is not in the cards. But I think to have this bond where it's at and just make it a 10% bond where the same $200,000 is posted is reasonable and fair, taking into the facts and his life.
So, counsel, if I set it at $500,000, 10%.
I don't think that's $500,000, Judge.
Oh, I can do math. Yeah, I get it.
That's. Can I speak with the family for a minute, Your Honor?
See, this is the issue, because he's saying this is not a reasonable bond, but he also in the same breath says it would be reasonable if it wasn't a surety so they could get the money back. So we can bring them, we can provide the money to release him, but we want it right back, so that's why it's unreasonable. So he does have access to the funds clearly to be able to actually pay the bond. So in this whole reasonable thing, there's no case law that counsel has applied to this court saying that this bond that's been set by the magistrate was unreasonable from the start. So At this point, Judge, I don't think the magistrate was acting outside its authority unless there's some law that can be provided. But based on the circumstances and the argument, I don't know how you are unreasonable at this point. Now it's just whether or not how we're going to pay for the bond.
Judge, my law is the Eighth Amendment to the United States Constitution that buy-in should not be excessive. Judge, again, I do think, and I know this, I've appeared before Your Honor, not a whole lot of times, but a few times. We had a case, I don't know if the court will recall, where it went on for a year before it went from district to circuit court.
Yes.
But I am confident. I mean, we have all of these people who are reputable people in the community. His employer, knowing that he's being investigated, said he can have his job. If the court wants to confine him to his home and not let him work, so be it. But to sit in the Washtenaw County Jail, given his background and history, where he has not even been charged yet with a homicide, I think just a $2 million cash or surety bond is excessive. I'm just repeating myself.
No, I know.
And
I will give you time to talk with the family. I'll take a recess.
Okay. Thank you.
Let you know.
All right. The additions to the second session, Honorable Judge J. Cedric Simpson presiding.
May be seated.
Judge, thank you for giving me the opportunity to talk to the family. There's 2 points that I thought of that the first is Miss Blanchard was kind enough to forward
Miss Blanche, you mean?
But did I say Miss Blanche? I'm sorry.
Yeah, you made her like the ex-governor.
The ex-governor.
I don't know. Go ahead.
Anyway, she was kind enough to forward me the email that she got from the medical examiner.
Okay.
And what it says, it does say a skeletal trauma, and it says a skeletal trauma analysis will be performed this month. Toxicology is pending. The circumstances are consistent with homicidal violence, but the body may not give a definitive cause. So it would seem to me, Your Honor, that if there was blunt force trauma, that would have been seen immediately to the skull. And I don't know what she means by the circumstances, but
Counsel, I think we need your client.
Oh, I'm sorry.
No, you just broke into argument.
Okay.
Thinking he probably should be here for this.
Shall I go get him?
No, you can go get him, but they'll probably keep you. No, you can't get here.
And I appreciate the court's infinite patience.
Sometimes it's all I have. Because you are better. Go ahead, counsel.
Okay. Again, Ms. Blanche was kind enough to forward me the email she received from the medical examiner. And it says the body may not give a definitive cause. And it says toxicology is pending. I mean, this could have been an overdose. We just don't know. But what to me is important is that the skull she was able to examine, and there's no statement in here that it was the result of any kind of blunt force trauma. The second thing I wanted to make a point of, which I think is really, I thought about this after the court granted us a recess for me to talk to the family. I think on one level, having to borrow money from friends and family is more a guarantee of an appearance than if you paid a bail bondsman, because this is his family, and he'd be letting down his friends and family that are willing to post the bond because they have faith in him. I don't know that I really fully understood, or at least I thought I did, but did the court ask about a $500,000, 10%, or $5 million?
Well, you were making the argument about getting money back and the like, and sort of balancing that against the something to guarantee his presence. And at least in my mind, that's what I was
certainly,
and so that's what I put that out there as you were arguing about the payment of the $200,000.
Anyway, if the court was inclined to raise the bond to something higher than 200,000 with a 10% provision, that would certainly be less onerous than a $200,000 cash bond. But again, the bond I suggested, which the court obviously doesn't agree with, I thought was reasonable, but even it's going to be difficult. They don't know whether they can post a $500,000 10% bond. They would certainly try, but I think they could post a $2 million 10% bond. So with that being said,
That they could post a 2 million if it were.
Yeah, it would take some.
10%.
Pardon?
If it were 10%,
Yes.
it could be posted.
Yes, the family could, they think they could gather enough money from friends and family to post that kind of a bond. And like I said, I think it is more of an assurance if he's indebted to his friends and family than to a bail bondsman who he has no connection with. And I given, that they may never be able to tell the cause of death. And certainly I understand where the court's coming from, that this could be a homicide. And if it is, then obviously the bond may change. But it's not there yet. And, in this country, we are presumed to be innocent. So I think the $200,000
Counsel, believe me,
I know you do.
that is not,
You just are worried about
it
the
is
danger.
not lost on the court.
I know.
That whole concept is not lost on the court.
Okay.
But what also is not lost on the court is the other pieces that are there that aren't necessarily being argued. I understand it hasn't been charged. I also understand that people can't charge a case until they have enough there to charge. But there are,
But I've
it's
conceded,
the
Judge.
fluid nature of the information that is causing the court some consternation, because this isn't, I have an event, we pretty much know everything about that event, and we're done. What I have here is we have an event of some type. We're not even sure what that event necessarily was, but we see some of the manifestations of it. And then there are pieces filling in, like the phones,
Right.
and those kinds of things that.
I get it. And Judge, I want you to understand this. When I made this bond suggestion, if it had been in a vacuum and there was no evidence that this could be a homicide, I would have not asked for a $100,000 10% bond. I would have asked for a lower bond. So it wasn't like it was lost on me.
No, I know.
That's why I didn't ask for a personal bond, because I do understand how the court might want to consider that there's an open homicide investigation. But again, my point is not that it's irrelevant, because I don't think it's irrelevant, and I don't think I've ever suggested that it's irrelevant. But what I do think is that it's relevant, but so is the life that he has lived that anybody would be proud of up until this point. And so again, if it's a $2 million 10% bond, the family thinks they could raise that. If the court thinks that a higher bond of a 10% is necessary, obviously we have to defer to the court. But I do think the $2 million cash or surety bond is just not reasonable and is excessive in violation of both the Michigan and the United States Constitution. And thank you for your time, Judge.
Thank you. Ms. Bryant, anything else?
I feel like I'd just be belaboring all the points I made before, but I am, like I said, concerned with community safety based on the fact she was last seen with him. She's found dead, and he's tracking up to Northfield. That's a huge concern. And even if it came back that she overdosed, he didn't even call. If that was, let's say that was the benefit of the doubt for best case scenario. He didn't call for medical. He did nothing. He dumped her body on the side of a road up in Northfield Township in our jurisdiction. So even if that was the case, nothing was done to help this person that was in his supervision at that time that he was with her. So even if that was the benefit of the doubt and that was the argument, that's what comes out, that's still, I mean, the fact that you're lying, making distressful representations to the police, lying to the police, and then this woman is found dead in our community. Honestly, Judge, a $2 million bond is not unreasonable under the circumstances.
I believe we are set for a PCC next week on the 25th. Okay, here's what I'm going to do, and I'm going to and I'm doing this for a reason, mainly to inure to the benefit of the defendant in this case. I've heard the argument here. You can supply me whatever other information you want to supply to the court. I'm going to make my decision. I'm going to move the PCC to 3 o'clock on the 25th, if that will work with counsel's schedule. I will also set my decision on your bond motion for that same time. I want to mull over some things. I want to look at it. I'm doing that, and usually I don't adjourn my decision on bonds to another date. I will usually make that decision, but I want to look very closely at some things. I also want defense counsel to at least get a preliminary look at the initial discovery that's there, so that and have an understanding of what the court may be taking into account with what the people have presented. So that's what I'm going to do. Like I said, I'm not accustomed to doing that. And if I felt that absolutely the magistrate's decision on bond was an absolute abuse of discretion, I wouldn't hesitate to rule immediately. But I can't say that in my mind at this particular point in time with what I see. But I want to give you a chance to counter some of what the prosecution has put forth. I don't think that can be countered without seeing that discovered. Go ahead.
I appreciate, the court taking the time to really, give serious to consideration. I don't know that once I see the discovery, that I'm going to have any answers. I'm obviously not going to put forward a position factually at this early stage of the case.
Correct.
But what I would ask maybe is if the court would consider lowering the bond to something that you suggested earlier, and then if I can supplement it, I will do that. But I'd like to give him the opportunity, at least at this stage, to try to raise some kind of a bond. So if the court would be willing to entertain that possibility, looking at it in the light most favorable to the prosecutor, set some kind of other bond that is currently set, and then if I can convince the court that
I don't think you, counsel, I get what you're saying. I don't think you want me taking what I know now, looking at it with benefit to the prosecution. I really don't think I understand why you're saying that to me, but I don't think you want me to do that, because if I do that, I'm done. And I don't think I should be, because I want to make sure that everything that you have is given to me, and then let me make my ruling. Like it, dislike it. But the one thing that you'll be able to say is that I looked at everything, gave everybody the opportunity to put forth everything before me, before I made my decision. And that's why I'm doing it this way.
Okay.
All right.
Thank you.
So the 25th at 3 o'clock.
If the court
will be the probable cause conference as well as that. Let me also ask this, Ms. Blanche, you may or may not know. There's additional evidence that obviously an investigation that's proceeding. Is there anything that's going to be anticipated as coming forth within the next week that would be relevant to this particular decision?
I can't speak to. I would have to, obviously. I know I've actively been reviewing search warrants just like today I have, so there will be stuff coming in. I don't know within the next week what we will have.
Gotcha. Okay.
I think the most important thing, Your Honor, at this stage is the autopsy.
Well,
cause of death.
Correct. But in terms of my determination as to whether or not this individual poses a danger to the community or not, I think that there are other factors that may come in that may play into the court's decision that I don't know. Okay.
Thank you.
Thank you. Yes, it was.
Okay. 25th at 3
Your
o'clock.
Honor, I filled out a handwritten appearance, but I had to cross out some numbers. So can I just file a typewritten?
You did not file an appearance?
I have it with me.
Well, hold it. Didn't we have him on the case?
I've been corresponding with Ms. Weidman. I have it here.
It's handwritten? Can we,
And he's been on the case.
and you've been on the
Yeah,
case,
correct.
so
Yeah.
He
it,
has his representation from.
I've been,
In the
I've
end, the judge does something rare and deliberate. Instead of ruling immediately, he pauses. He keeps the $2 million bond in place, not as punishment, but because fairness requires full information. The court makes one thing crystal clear. This decision is about caution, not guilt. An open homicide investigation, evolving evidence, phone tracking, and unanswered questions demand careful review. The defense will get discovery. The prosecution will continue investigating. And the court will revisit bond with everything on the table. This is what due process actually looks like. Slow, uncomfortable, and methodical. Now I want to hear from you. Was this bond excessive, or was the judge right to prioritize community safety over convenience? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Counsel, if it's handwritten, as long as I can read it, if you write like a doctor, I'm going to have a problem. But if I can read it, I'll take it. All right. You don't have to go back and type it. Okay. But yeah, that will be fine if it's handwritten. Okay. Anything else from either side? Okay. So at this time, bond will continue pending the hearing on the 25th. All right. And folks in the courtroom, thank you very much for the manner in which you conducted yourselves. The court does very much appreciate that, that everybody behaved. All right. Thank you.